you're getting a notification, hopefully. And Caitlin, I'm gonna pass it over to you.
Okay, awesome. So can everybody hear me okay? Okay, I'm seeing thumbs up, head nods. That is great. If there's any sound issues, throw it in the chat, and Laurel can interrupt me. But like Laurel said, my name is Caitlin Bradley. I'm the on-staff attorney at the Action Alliance. I work with a project called the Project for the Empowerment of Survivors, or PES. And my email is here in this PowerPoint. The office line is there, but email is usually the best way to reach me. I work with survivors all over Virginia that are experiencing sexual or domestic violence. We provide free and confidential legal advice over the phone to survivors. And I also do a lot of TA with advocates. So if for any reason you feel like you would benefit from a conversation with me, or a client of yours would, do not hesitate to reach out. That email is there, and please reach out. I also just want to thank Laurel for all of the support on this call. I'm sure that this would be a mess if I was trying to like manage the technology and all of this at the same time. So thank you, Laurel. And then I also wanted to thank Ruth Micklum, who is on the call today, and who facilitated the last session of this series. And I hope that if y'all weren't able to catch that the first time, it is on YouTube. So I would just encourage you to watch it. I thought it was very helpful. A lot of history and overview of protective orders that, as you know, younger person in this movement, I'm not as familiar with, but it's super helpful to get that background. And she did that with Sushila Barkey from VPLC. And they are going to be hosting, as a reminder, next week is it's a live Q&A session with a couple legal aid attorneys. And so what next week's session is really going to be is a sort of real world application opportunity to ask legal aid attorneys just your questions, you know, more about how does this actually work in the real world. Today's session is really going to be about nuts and bolts and sort of some of the more nitty-gritty like technical aspects of protective orders. But I think next week will be a really great opportunity to hear from practitioners on the ground and ask your questions. And so as a reminder, Laurel has put the link in the chat, and that link is a survey that you can use to submit your questions. All the questions need to be submitted ahead of time, and I'm going to go ahead and close that link at the end of today at close of business. So use that link to submit your questions. I'm going to compile those and give them to Sushila so that next week the attorneys can be prepared for the questions and come prepared with answers. So use that link, submit your questions. I'm really excited for next week. I think that it's a great opportunity to just get some real world advice on this kind of thing. So like I said, today's session is really going to be a basic overview of protective orders, the forms, what to expect. And so this is really intended for folks who are newer to protective orders, and it's a more I guess basic overview, but we're definitely going to be getting into some interesting topics that come up. So Laurel, if you want to go to the next slide. This is just a roadmap. I like it. Okay, I think it's going to show up one by one. Cool. All right, so yeah, basically this is what we're going to cover today. We're just going to define protective order and different types of protective orders. We're going to go over representation and venue, family abuse protective orders, non-family abuse protective orders, remedies, or another word for that would be relief. So in other words, what a protective order can actually do for your clients. And then we're just going to talk about extensions, modifications, and violations of protective orders and how those are handled. All right, so if we go to the next slide, we're going to just start with a little check-in question. And Laurel, you can explain how this will work, the annotation feature. But Laurel's going to tell you how to annotate the screen, but if you can annotate sort of where you feel where folks feel in terms of your comfort level discussing protective order options with clients, just so we can get a feel for where folks are at in the room.
Yeah, so to annotate, what you can do is on the screen that you're viewing, if you go to the top of it, you just kind of bring your cursor up to the top, it'll give you a little drop-down toolbar, and on that toolbar, one of the options will be annotate. It has a little pencil kind of emoticon with it. You can click that and choose to either use a stamp, which I see lots of people are using the stamp so far, which is awesome, to mark on that image where you're feeling. If you're unable to annotate, I would encourage you to, in the chat, use a number 1 through 5, 1 being that scared red face and 5 being that excited green face, as to where you might fall on this spectrogram. And it looks like thus far, ooh, someone's way off. Someone loves talking about POs. They're off the map even, but we have a pretty good concentration of folks who are towards the right-hand side and the pretty positive side, maybe a little bit in that middle section, and only a few who are indicating that they're nervous or uncomfortable talking about POs. And in the chat, I'm seeing someone has indicated that they're a 2, and a couple more people saying they're a 5. So we got a mixed group here.
That's awesome. Okay, cool. So yeah, we've got, it looks like people are pretty comfortable. And so, you know, I hope that this is helpful and that this increases your comfort level with that. But I'm glad to see that folks are familiar with these, and I'm sure coming across these every day in your work. So that's cool. And we'll do this again at the end and see if any of this, see if this picture changes. So if Laurel, you want to go to the next slide.
Mm-hmm.
So really briefly, we're just going to define a protective order, and Ruth and Sushila went into this last week a little bit, but a protective order is a legal document issued by a judge or a magistrate. It's intended to provide a person protection against violence. That's the intention, is to protect the health and safety of the petitioner. In Virginia, we have what are called general protective orders and then family abuse protective orders. Sometimes general protective orders are called non-family protective orders. Those are handled in 2 different courts, and we'll get into that. And then there are 3 types: emergency protective orders, preliminary protective orders, and then quote unquote permanent protective orders, which tend to they last up to 2 years. They can be extended, and we'll talk about that in a bit. But this is distinguished from a no contact order. So a no contact order is something different than a protective order. A protective order is a civil order. So it is a civil action that is initiated generally by a petitioner, by the victim. A no contact order is a condition associated with a criminal case. So judges have jurisdiction and the ability to order a defendant in a criminal case to not have contact with the victim. That operates independently from a civil protective order. And a lot of times victims feel somewhat of a false sense of security if they have a no contact order. Because they may feel that, well, I'm good, I don't really need a protective order, I have this no contact order. The important thing to understand is that if or when that criminal case is dropped for any reason, the court loses jurisdiction over the defendant. So therefore, the no contact order will get dropped. The petitioner or the victim has a lot less control in a criminal context than they do in a civil context. So even if a victim has a no contact order, it is important to explore the civil options as well. And then I just want to also distinguish this from a restraining order. People use that word, and usually what they mean is a protective order. A restraining order is a real thing. It is just something different than what we think of. A restraining order is a tool in complex litigation that is used to prevent certain behaviors of the parties, but it has nothing to do with domestic violence. So, so when we're talking about restraining orders, usually what people mean is protective orders. So really briefly, when we say that there are 3 types in Virginia, there's emergency, preliminary, and permanent. Those are, the acronyms used for those are EPO, preliminary protective order, and then a final protective order is usually the way people talk about those things. they do not necessarily, one does not necessarily lead to another. So an emergency protective order only lasts for a short amount of time, and it does not automatically turn into a longer protective order. So it's important that advocates understand that an EPO really is just a way of buying a little bit of time, usually to allow the petitioner to go to court to file the preliminary protective order. It will not automatically go 1, 2, 3. So they are separate and distinct things. And then if we'll go to slide 2, venue for a protective order. So this is basically, venue is where do you file a protective order. So the appropriate venue for a protective order is where either party has principal residence or where the act of violence, force, or threat occurred. You can also file where a protective order was issued if at the time of proceeding is commenced, the order is in effect to protect the petitioner or another household member. So basically, if you're going to modify a protective order or extend it, you need to file that in the same place that the protective order was issued. But generally speaking, you're going to file either where the victim lives, where the respondent lives, or where the act of violence occurred. There's different reasons that a victim may choose to file in one venue over another. For instance, if there's a criminal case related to the same incident, that is going to take place where the incident occurred, irrespective of where either party lives. So let's say that you have a victim who lives in Henrico, a crime that occurred in Richmond, and a defendant that lives in Chesterfield. A victim could choose to file in any one of those places, but if there is a criminal case moving forward in Richmond, it may make sense to file the protective order in Richmond, because in some instances, courts will combine the hearings and hear them at the same time. And if you're going to have your witnesses there or the police officers there, it may make sense to sort of piggyback on that. It also might make sense if there is a related custody matter happening in another in another venue to put that in the same court. So let's say in this hypothetical, the crime occurred in Richmond, but the parties have a custody case going on in Henrico. It may make sense for that victim to file there. These are just different options that the victim has, and it is the victim's choice, where to do that. I want to make a point, though, that I really want to distinguish between two concepts. One is venue and the other is jurisdiction. Those are not the same thing. Venue must be proper in order for the court to proceed in a protective order hearing, but the court must also have jurisdiction. And jurisdiction basically means the court's authority to make an order over a person or a thing, like a property. So jurisdiction can become a problem sometimes if the court doesn't feel that it has jurisdiction to make an order against a person. So an example might be if you have a victim who recently relocated to Virginia from California, and her abuser is in California, and the abuse took place in California, and the abuser has never stepped foot in Virginia, we can look at this venue statute and we can say venue is proper in Virginia. But a court is not likely to exercise jurisdiction over a person who's never stepped foot in the Commonwealth of Virginia. So you may have problems convincing a judge that he or she or they have jurisdiction over a person who lives out of state. Not only will you probably run into jurisdictional problems, you may run into service problems because the respondent needs to be served with the protective order. So it's just important to understand that these are potential roadblocks that could happen. Most states have what's called a long arm statute, which means that they can essentially reach their arm out and extend jurisdiction over somebody if that person has made what's called sufficient contacts with the jurisdiction. So this would be, like, an example would be, I know that folks live near borders, right? So let's say that you're working with a victim and maybe the abuser lives across the state, maybe they live in Maryland, right? But they travel frequently to Virginia for work. Or let's say they are harassing the victim from Maryland. There are some creative arguments to be made that, if they're texting, right, they're making contacts with a person in Virginia. So they are essentially putting themselves in the jurisdiction of the courts in Virginia by behaving that way. So it's not impossible to get a court to exercise jurisdiction over a person in another state. It's just it can be really tricky. The other thing to bear in mind is that courts are not necessarily going to take jurisdiction over property in other states. So again, if the victim who recently fled from California is asking a Virginia judge to award her possession of a house in California, the court is probably not going to feel that it has jurisdiction over a piece of property not within Virginia. These are just potential challenges to just be aware of that can happen. The other thing is the court in a protective order hearing, remember this is a civil hearing. It is one party against another party. The court does not have jurisdiction over third parties. In other words, other people or entities that are not a party to the action. So sometimes what that can look like is a victim says, I want him to stop contacting me, and I want his mother to stop contacting me too. In a protective order against the abuser, the court does not have jurisdiction over the mother-in-law, right? This person, this third party, is not a party to the action. So it's unusual or unlikely that a court would make an order against a third party. Another example of a third party would be a lender. So frequently you'll have a victim say, we're both on the mortgage and I want the judge to order him to let me off the mortgage. There's a third party involved in that contract and it's a lender, it's the mortgage company, right? So the judge does not have jurisdiction over the mortgage company to order that company to let her off the mortgage. So that's a third party that's not part of this action. So all of that to just say, judges, even though they seem all powerful, they do have limited jurisdiction, and that jurisdiction is defined by statute. So then just because venue is proper does not mean that the court is going to have jurisdiction over the other person, over property, and definitely not over third parties. So there is a limited scope of what a judge can do in a protective order hearing. So anyway, moving on to the next slide. This is a little map of Virginia's court system, and if you are new to Virginia, you'll know, or if you've ever worked in another state, you'll know that all states have a different map. All states have a different structure to their court system. So this is what it looks like in Virginia. We've got two courts of limited jurisdiction. So that's the general district court. Well, they're all general district courts. So you've got the GDC, and then you have the juvenile and domestic relations courts, or JDR courts. Those courts can only hear certain types of cases, and they're considered courts of no record. And one thing to know if you're new to Virginia or new to the court system in general, a court of no record is not a typical type of court. It's not something that most states have. It's very unique to Virginia. So a court of no record is basically a confidential court. It's a court where there literally is no record. The proceedings are not open to the general public. There is not a court reporter taking notes. So what that means is, and then generally speaking, you can't look these things up online. So all protective orders start in a court of no record. And we'll get into the different types of protective orders, but basically non-family protective orders or general protective orders are going to go to general district court, and family abuse protective orders are going to be heard in JDR court. It's important to understand that the next level up is a circuit court. So that is also a trial court. Both of these courts are trial courts, but in Virginia, we have this dual system where there's basically two levels of trial court. And circuit court is sometimes called the higher court. And basically what it means is that it is a court of record. There is a record, and all final orders that originate out of GDC or JDR, the courts of no records, are appealable to the circuit court. Appeals need to be filed within 10 days. So there's a 10-day window for appeal, but what that means is that if a protective order is issued by a judge in, let's say, JDR court, either party has the option to appeal that protective order, which would then bump it up to circuit court. The circuit court hears those appeals on what's called a de novo basis, which means it's a brand new hearing. Basically, it's as if the lower court never happened. There is no record of it. Generally speaking, there's no record of it. And the court is going to hear the evidence anew. So this can be really hard on victims, because when they walk out of one court, they feel, if they've been granted a protective order, like, great, I did it, end of story. And then they get a notice in the mail that it's being appealed. And what can oftentimes happen is they get basically dragged through the process all over again. They have to put on all the same evidence. The difference being this time, the respondent knows what evidence is coming, right? So, they in some ways are given an advantage because they know what the petitioner is going to say and use against them. But it's also important to remember that it can work in the favor of victims too, because they themselves can, if a protective order is denied, they can also appeal that. Whatever decision is made at the lower court level is going to stay in place pending the appeal. So if the court issues a protective order and says, okay, 2-year protective order, and the respondent appeals it, that protective order is going to remain in effect until the circuit court hears that case. Similarly, if the lower court denies a protective order and the petitioner appeals that, the protective order will remain not in effect until the appeal. So it's just important to understand the appeal process. It's not difficult to file the appeal. There's just a form that gets filed and sometimes a fee which can be waived. So it's just important to prepare your clients for the possibility of appeal, because this can be a really traumatic surprise for victims to find out, for them to get their hopes up and then find out that it's not quite over. So if we go to the next slide, like I said, this is really just the statutes here. That the purpose of a protective order is really to protect the health and safety of the petitioner and other household members. And generally speaking, that means children. I underlined the, and Laurel, I think if you click it a few more times, the words will show up. I underline the health and safety aspect here because it's really important to understand that from the court's perspective, from the judge's perspective, regardless of whatever else is happening in these folks' lives, the purpose of a protective order is about health and safety. And there may be a lot of other issues. There may be financial issues between the parties. There may be custody issues between the parties. But the focus of a protective order is health and safety. And this can be hard on victims because they frequently have multiple types of cases going on, right? They might have an eviction going on, a divorce, right? Custody, and all the issues start to blend together. There's, oh, well, there was adultery, there's the kids, there's this lease that we're on together, these bills. And that for a victim can just, it's just all kind of one big ball of wax, okay? But it's important that victims stay on track and understand that in a protective order hearing, the question before the court is whether or not a protective order is necessary to protect his or her or their health and safety. So relief sought in a protective order really should be in furtherance of that goal, protecting the health and safety of the petitioner. And one note I do want to make is that this is about the health and safety of the petitioner, not the health and safety of the respondent. So it used to be that I would sometimes get calls or hear from survivors who had concerns, I mean, real legitimate concerns about the health and safety of the respondent, meaning They were afraid that, you know, it's like, my husband's going to kill himself, so I'm going to file a protective order. Or he has a substance abuse problem, he needs to get into treatment, so I'm going to file a protective order. A protective order is not the appropriate remedy if what the victim is actually concerned about is the respondent's health and safety. And now that we have these substantial risk orders, I am really curious how those will work, because that would be the appropriate remedy for somebody who is a danger to themselves and who needs, you know, for instance, firearms removed. But sometimes those issues get blurred, and a victim is both afraid for their own safety and the respondent's safety. But just from a clear statutory perspective, what the judge is concerned about, the question before the court is whether or not the petitioner, their health and safety is at risk. So, all right, we'll move to the next slide. So this is the definition of family abuse. Again, every state is going to have a slightly different definition of family abuse or domestic violence or whatever the phrase is in that state, but here we call it family abuse, and it is defined as any act involving violence, force, or threat that results in bodily injury or places one in reasonable apprehension of death, sexual assault, or bodily injury. And that is committed against a family or household member. Now, that family or household member is also a defined term. But when we look at our definition of family abuse, primarily it involves physical violence. It can involve behavior that places one in reasonable apprehension of violence. So that doesn't mean necessarily that there needs to be physical contact, but there needs to be behavior that speaks to violence, right? So threats of violence, actual violence. It can also include stalking, detention, and sexual assault. But in general, when we look at what the definition is that grants a judge the ability to order a protective order, it must be, for the most part, related to violence. As we all know, there are lots of forms of abuse that go on in relationships. And those violence is not always necessarily the worst part or the most important part to a victim. A lot of times victims present with a lot of concerns and a lot of things that have happened in the relationship that they want to talk about. And there's a real desire on the part of victims to have their day in court and to have those things heard. But what is super important as an advocate is to help victims understand that when we look at this definition, this is the guide that tells the judge what he or she needs to listen for. And so the victim really needs to speak to this in court. And it doesn't mean that those other forms of abuse aren't horrendous and harmful, and they do deserve to be acknowledged, but in a limited amount of time before a judge. This is the focus is on physical violence. So if we go to the next slide, this is the definition of family or household member. And I thought that Ruth and Susheila's overview was really interesting, because when we look at the history, generally speaking, these were really limited to spouses, but the definition of family or household member is actually quite expansive at this point, and it really does include non-intimate partners as well as intimate partners, because it does include parents, step-parents, children, stepchildren, brothers, sisters, half-brothers, in-laws, things like that. This does not apply to, when we say children, we don't mean minors. This would be between adults. So basically, you can't file a protective order against your teenager. Sorry to tell you that, but you can't. So we have intimate partners here. It's important to look at this definition, though, because when we look at cohabitating couples or dating couples who don't have children together and aren't married, there is this 12-month limit. So basically, if they cohabitated longer than 12 months ago, they would not be considered family or household members. That does not mean that they can't get a protective order. It just means they don't meet this definition, and they should file in general district court. My recommendation is if there is confusion on this point, talk to an attorney and say, does this person qualify as a family member? Where there is a gray area on cohabitation, like it's not, they sometimes sleep over and sometimes don't, and are they cohabitants or are they not? Generally speaking, my recommendation is if you don't know, and if that's going to become an evidentiary issue, just go file in GDC, because then you don't have to prove that you're a family or household member. When you file in JDR, you have to prove that an act of family abuse has occurred and that the parties are family members. So if that's going to become an issue, I would not recommend I would not recommend that a victim take on the burden, the additional burden of proving that they meet this definition.
Caitlin, a question just came up in the chat that I wanted to uplift. Diana was asking, wanted to confirm that they heard correctly, that a parent can't request a protective order against their minor child, but they can against their adult child.
Yeah, yes, correct. So, and vice versa, right? So an adult can request a protective order against their adult parent and vice versa, but yeah. All right, so moving to the next, this is the types of relief that can be sought in a protective order. Relief is basically anything that the petitioner is asking the court to order. And so in a family abuse protective order, the biggest difference I think that you're going to see between a non-family and a family protective order is that the relief is going to look different. And that's because if parties are family members, they're going to have more entanglements and more relief that they need than, let's say, two neighbors and one files a protective order against them. They don't share bills, they don't have children in common, they don't need the same types of relief. So the types of relief are going to look different. But in a family abuse protective order, the court is authorized to impose many limits on the respondent. And it's important to understand that this is a one-way order. The petitioner is not subject to a protective order. They merely requested a protective order. The respondent is the person who is subject to the order. So a petitioner, legally speaking, cannot violate their own protective order. And we'll talk about that later, but a petitioner can't and should not be criminally charged with a violation of a protective order that they're not subject to. So the respondent is the person who the limits are imposed upon. And a protective order can prohibit acts of family abuse or criminal offenses that cause injury to person or property. So basically, this would be considered, a lot of people, if only that box is checked, well, one, it's important to understand that would be a protective order that is ordering the respondent to not do something that is already criminal, that they're already prohibited by law not to do, which is commit an act of family abuse or criminal offenses. That is not to say that that protective order doesn't matter or isn't useful. Like Ruth talked about, there still are going to be firearm restrictions on that respondent, but that's not going to prohibit any type of contact between the parties. So it is theoretically possible that a petitioner could go in, only have that box checked, and they could go home and live together with a protective order in place. The real big one is the no contact box. Okay, so the no contact order would be a provision of the protective order that prohibits contact between the respondent and the petitioner directly or indirectly. So indirect contact looks like, a respondent sending a message to the petitioner through his friend or through her friends. That's indirect contact, and that would be a violation of a protective order. It can grant the petitioner temporary possession of the residence occupied by the parties, and it can prevent the respondent from terminating utility services on that residence. That's something that I'm sure at some point was added because that is the type of thing respondents do out of vengeance, is just shut off the utilities. So a court can order them not to do that. It can grant the petitioner temporary possession or use of a motor vehicle, require respondent to provide suitable alternative housing for petitioner. And several other things. One thing I really want to clarify, though, when I say that the order can grant possession of the residence to a petitioner, once again, that's not going to affect the title or the mortgage interest of any real or personal property. Those, again, are third parties. So a protective order is not going to actually change who has a legal interest in a property. That's different than the word possession. It can grant the petitioner possession of a residence. So, for instance, if an abuser has a lease and the victim moves in, is not on the lease, a protective order could grant her possession of that property and kick him out, but a landlord still has the right to evict somebody from a property who's not supposed to be there because they're not on the lease. So just remember that there are just third parties in the wing all the time that are not subject to this protective order and are not controlled in any way by the protective order. But the possession of a residence is really important. As many of you know, as people are separating, this becomes really urgent and important. So if we go to the next slide, a protective order, occasionally judges can order respondents to participate in treatment or counseling. I don't see that very frequently. That would probably be a, I don't see that very frequently, but it is possible. And then the court can grant temporary child support under certain circumstances. So, and make temporary custody orders. So sometimes what will happen is you'll have folks come in who they have children in common, and they don't have any current custody or child support order, and a protective order can operate in some cases as like a stopgap measure, can provide for those civil orders, and create some temporary relief until the parties are able to get into a more permanent hearing regarding custody and child support. I will say that if, and this is, I think, a good question to raise with the panelists next week, if parties already have a custody order in place, so let's say that there's an existing custody order, an existing child support order, and then an act of violence occurs, an act of family abuse occurs, a petitioner can file that protective order, and they may be tempted to ask for some custody or child support relief because it's right there looking at them in the face. Judges, in my experience, don't like that, because what they don't want to see, people using protective orders as shortcuts to get custody or child support. So when people are using a protective order to make a change to an existing order, that will probably not look great for the victim, because it may, to the judge, appear that they're abusing the process, even if that's not what victims intend. That's oftentimes what victims get accused of, is using protective orders as custody grabs, or that kind of thing. Any sort of custody or child support order or whatever is going to get superseded by the real thing. So in a real custody action, there'll be a real, permanent custody order and child support order, and that's going to supersede the provisions of the protective order. I have run into situations where victims are a little confused on this point, and they will get a protective order that lists the child and says no contact, and then be really disappointed to find out that that in a custody case, the father is granted visitation. And they're like, well, why can't we just go back to what it was in the protective order, which was no contact at all? And I would say to that, I mean, that is an unrealistic expectation to believe that a judge will terminate a parent's right to see their child altogether. That is a totally separate type of action. It's pretty serious. And so to the extent a protective order grants a very favorable custody or child support order, it's important that victims understand that's not really meant to be permanent. And it's not something to like pin their hopes on. This is going to set the precedent for what's next. It may or may not, but it's not either way, it's not meant to be permanent. So
Caitlin, we had a question come up in the chat from Dawn. Can a petitioner be given possession of a vehicle where their name is not on the title?
yeah, so yes, and that would probably be temporary. So if you know, if let's say parties are married and that is marital property, but the name is not on the title, yes, a court can grant temporary possession of that, but in a divorce proceeding where that property actually gets divided up more permanently, that can be superseded. So, but yeah, it's theoretically possible. Yeah. And just moving on to the next slide, I do want to distinguish between like what's possible and what's likely. Judges don't, judges have a whole array of things that they can do in a protective order, and victims have a whole array of things that they can ask for. But it's not the case that judges grant everything. They use their discretion about what to grant or what not to grant. So like in that hypothetical with the car, I would say if the parties are not married and that's not marital property, I don't think it's very likely that a court would give the other party the possession of the car. It's not impossible, but I think it's not likely. All right, so if we go to yeah, basically the preliminary protective order lasts 15 days or until the full hearing for a PPO. The petitioner or their attorney can file the petition for protective order, non-disclosure addendum, and a UCCJEA affidavit. So basically that is telling the court that Virginia has jurisdiction over the children. And then once filed, a hearing is scheduled as soon as possible. Usually within that 2-week window. If by the time the hearing comes, the respondent has not been served, the court can continue the preliminary protective order, keep that in effect, and reschedule the hearing until the respondent is able to be served. So that it's not that the victim is left without protection. On the other hand, if that goes on for a very long time, like 6 months, and like the court can't serve the respondent, then eventually the court probably will drop the protective order. But it is to say, I just say that to say that if the issue is service, effectuating service, the court can extend the protective order longer than that, the preliminary protective order longer than that 15 days. The preliminary protective order is effective immediately, but it's not enforceable until the respondent has been served. In other words, a respondent can't get in trouble for violating something that they're not aware exists. So, but that it's still, the minute it's signed by a judge, it is effective. And so the victim doesn't need to, let's say, wait. If they're granted possession of the home, they don't need to necessarily wait for the respondent to be served to go back to the home. What they can do is they can bring the police with them and have the respondent served. Ruth mentioned in the last session that that protective orders are uploaded onto the statewide system. So if the police are called out, they should be able to pull up the protective order and print it and have the respondent served with that protective order. But like I said, the respondent can't be charged with a violation until they've actually been served with it. And if we move to the next slide, and I think Ruth and Sushila went over this, but there's no cost to file it. You can, the petitioner should bring a copy of the an emergency protective order to the hearing if there was one. And in order to file, they will need the name and address of the person they're seeking the protective order against. And that's because they need to be able to personally serve the respondent. So you can't put a PO box. They need to know where to actually find this person. A full description of the event that led to them seeking the protective order, and we'll talk more about that in a moment. And when they go to get the preliminary protective order, they can bring evidence, photos, things like that. So moving on, The permanent protective order can last up to 2 years, and the petitioner may request that a protective order be extended in certain circumstances. And either party can file a written motion at any time requesting that the court modify or dissolve the order. So if the parties decide to reconcile, or for whatever reason the petitioner wants to drop the protective order, they can go to court and ask the court to drop that protective order. The respondent can also ask for the protective order to be dropped, and this is why I say that a victim who is quote unquote violating their own order by contacting the respondent, it's not so much that the risk is that they would be criminally charged with the violation, but the respondent can bring evidence that the petitioner is repeatedly contacting them and use that as the basis for a request for the court to drop the protective order. So in other words, if the respondent is able to show, well, she's called me, 5 times in the last week, this protective order should be dropped because clearly she doesn't need it or want it anymore if she keeps contacting me. So that's where I would say that victims should be aware that if they contact the respondent, if there is a no contact order in place on that protective order, they run the risk of, giving the abuser leverage that they need to get it dropped. Just moving on again, just to reiterate, it can be appealed within 10 days. So violations of a permanent protective order and a preliminary protective order can be criminally charged or considered contempt of court. And then if the protective order is granted, there is that restriction on firearm possession. And Ruth is going to go a little more into firearms in the 4th part of this series. So we're just going to move through and kind of look at what these forms look like for folks who have not yet worked with these. So moving through, this is the petition. And if you move to the next one, this is what it looks like. This is the summons for the hearing. So the court will put a hearing date on here. And this is the information where we include like the respondent's description. That's for purposes of serving the respondent. The title of the case is going to be the petitioner versus the respondent's name. There'll be the time, place, location of the court will be there. And if you go to the next slide, this is what the petition looks like. It gives petitioners this little tiny space to write what happened. And sometimes, protective orders, the victim will write something really simple like "he hit me," right? Like that is sufficient, right? It should be sufficient to get a protective order. But if there's a longer story involved, you can check this little thing that says "see accompanying affidavit," and the victim can actually write out a fuller version of events and have that notarized. This is important because victims seeking a preliminary protective order may not always get the chance to tell their story. This may be the only thing that that the judge sees, right? So especially with COVID, a victim may not be able to tell their story. So writing a good narrative, I think, is really important. And then if we go to the next slide, this is some of the relief that can be requested is on this form. And then if you go to the next, this is what a return of service looks like. So basically, the court needs to have proof of service in the file at the full hearing in order to move forward. One thing I'll quickly say is on that first form, whatever relief the victim is seeking, I'll just make this suggestion, and I'll be curious to hear what the panelists say in the next session. But I think it is if the victim asks for 1, 2, 3 things and then changes their mind and at the hearing suddenly decides, oh, I actually want this extra thing, right? Like I want no contact, I want possession of the home, and then they get to the hearing and they're like, oh, and I also want child support. It's difficult just from a due process perspective for the court to change the scope of what the victim is asking for at the hearing. So whatever relief the victim wants, they should put that in the petition, in the request. They should immediately put that out there, because it's going to be difficult to ask for more later. So if we move forward, there's a non-disclosure addendum that you can include, and we can
There's some questions that have come up in the chat, Caitlin, that I just wanted to make sure. So Sheila already spoke to one of them in the chat, which is great. Thank you so much. But Royale was asking for POs that are granted by a judge as a part of a sentencing for the new law of DV or IPV related charges. Would that still be a family abuse protective order, or would that only be in cases that a defendant is sentenced in JDR? And so Sheila responded, looking for some exact language to share, and if you wanted to weigh on that. And then Alana also was sharing some thoughts about clients that they've worked with in the past are really reluctant to file up for a PO because they're afraid that their abuser may have to give up a firearm that will result in the abuser losing a job. So it's accurate to say that they won't have a firearm removed as a result of a PO unless the petition to remove firearms is filed?
So no, no. So, and this is one where petitioners don't have the option of saying, I want a permanent protective order against this person, but I still want them to have a firearm. That being said, my understanding is that there are exceptions for people who like have a duty to carry a firearm, so police officers or military personnel. And so I can't speak to that with a lot of experience, but I say that to say that, I mean, protective orders are serious. They show up on background reports, and they do prevent the respondent from possessing a firearm under normal circumstances, but I do believe that there are exceptions, and I don't know much about those. But you know, as far as military personnel, I do think that there are exceptions. So you know, I understand, and I've run across this too, that it, you know, might affect a security clearance, or it may cause them to lose their job. I guess the difficulty I find with that is that I usually tell victims, I'm not sure that I trust your partner's story, right? That there's no option for him to seek an exception, or that, you know, I think that abusers use that as an excuse. And so without having firsthand knowledge that that actually is the case, I don't usually trust abusers to be honest about that. But yeah, I don't know much about the exceptions. I don't know if Sheila or Ruth have had experience with that, but so Jonathan's pointing out that, I mean, that I think that's a good thing we can get more information on for part 4 is those exceptions. But yeah, those are, I do know that in some places I've been, there have been exceptions for, I guess, duty bound people who carry firearms because they have a duty to, but I don't know the specifics on that.
Yeah, Caitlin and folks, I'm gonna say I will look into that, because I don't know with the new firearms provisions making it a felony, if there are options for that. So unless Sush, knows something, I certainly want to look into that for the next one.
Yeah, and this is Jonathan. I don't remember seeing in the drafting of the legislation or in the conversations at all that happened in various work groups or in the legislature that there were specific carve-outs for, as Caitlin was saying, duty-bound folks who may be also respondents of protective orders. But yeah, Ruth, I mean, there might be something somewhere that we just didn't catch.
Yeah, I will certainly cover that in the firearms presentation. We'll do some checking of that, but I don't think right now there would be an exception. However, judges actually do that. The difference is with the passage of the new firearms legislation, it is now a felony to possess a firearm, and there aren't like legislative carve-outs for that. So
That's my understanding too, everybody. I'm of the same mind. I think that's the issue about military people being respondents in protective orders, that they could basically lose their jobs because they can't carry firearms, right? So there's a whole nother military protective order process that's an internal military thing that's separate, which I really don't have a lot of intelligence about.
Yeah, I mean, it's a great question though, because yeah, it's not, you know, that's a legitimate concern, is if, you know, the abuser is a source of support, then, you know, losing a job is not going to help the victim ultimately. Yeah, and Sushil, I don't know much about the military protective orders either. The only thing that I do know is that victims don't have a lot of control in that process. So similar to the no contact, you know, if you're working with somebody who's a non-service member and the military has decided to put a military protective order against the service member, they again may have a false sense of security, like, well, I don't really need this civil option. And, you know, my suggestion is the civil court is the one you're going to have more control in. So, but I don't know a lot about that process either. And military court in general is very different. So I don't have a lot of expertise there. But so Laurel, if we just move forward to just move through these slides, and then we'll go to this non-family abuse protective order. There's a very similar definition here that it's the same type of behavior that is required for a general protective order. So again, it's very focused on violence. So again, this is for folks who are non-family members, but the definition is very, very similar. So that is just there. And if you move to the next slide, really what looks different is the type of relief. So you have the same relief on, you know, you can prohibit acts of violence, force, or threat. You can also prohibit contact. So you can also have no contact here, other relief, companion animal. But you're not going to really see the custody stuff here, the possession of a home stuff, because these people, again, they're not family members. They don't have those connections. So that type of relief should not be necessary in a general a general non-family protective order. So the big difference you're going to see here is basically, you know, in the type of relief sought. So if we move on, yeah, this is basically the non-family abuse, very similar process. You file you know, you can get an EPO, the preliminary can be filed and then would be followed up by the permanent hearing. So very similar process, similar forms. If Laurel, if you'll advance to, so yeah, I want to talk a little bit about preparing survivors for court. So basically, I think that advocates have a big role to play here, because I really think there's quite a bit of work that an advocate can do with a victim to prepare that victim for court. And unfortunately, you know, lawyers don't always have the time that it takes to do a lot of the processing that's required to adequately prepare a survivor for court. And so this is where I do really feel that advocates working in tandem with lawyers can really tag team and really help a survivor be well prepared for court. So it's important that that survivors understand what a protective order can and can't do. If that's getting close to, you know, the line of legal advice, I think that, again, having that relationship with your local legal aid or other lawyers can help to sort of field those questions. But general questions, advocates can talk to victims about what protective orders can and can't do. And the biggest thing I really feel is that survivors need to be able to tell their story however they want to tell it. And all of us working with victims know the story doesn't come out clean. It doesn't come out linear. Not everything they're talking about is relevant. But that messy version of the story, in my experience, victims have to be able to tell their version of the story at least once. And that is best done in your office, not on the stand. That messy version, just, there is not time. Judges don't have the time, or frankly, usually the patience for that. And so what, in my experience, helps is to allow that to happen however it's going to happen once. And when I was an advocate, what I would do is I would listen to the story and I would take notes on a line, right? And I would create what sounded like a timeline to me. Now, the victim wasn't telling the story start to finish, but what I started to do is pull apart events they were telling me, because it was, you know, our brains, especially in trauma, don't work from, you know, a linear perspective. So I would take what they were telling me and try to put it in order of events, right? And then I would show them and say, you know, this is what I heard you say, and this is the order, this is the timeline I understood. Could you help me confirm that, right? And that process with a victim, helping a victim put things in order, is extraordinarily helpful, because by the time they get to their lawyer, I mean, you might be, you know, their legal aid attorney may have 15 other cases that day. The processing and all of that, it's very time consuming. If you can help your client do a lot of that legwork before that, I think it's going to help a lot. So one thing that I would say, the judges usually want to know, what was the event that happened right before this protective order, right? What was the thing that triggered the victim to go to court? That may or may not be the most extreme abuse that did occur, but I will say that most, at least again in my experience, what judges oftentimes want to know is what happened leading right up to this. And I would say that there's generally, I think, an unfair amount of skepticism that has developed against victims over time. And I think that a lot of times judges are trying to sniff out, well, are you doing this because you're mad about something dumb, or you're trying to take advantage of the system, or whatever? But it is important that the judge understand, well, what led up to this moment, right? Like, why did this, what happened right before this that led this person to come to court? So I think that the background is super important, right? If there's a history of abuse, that's important. But I think it's important to pretty upfront tell the court why now? Why is the petitioner seeking protection now? I would say a couple things I've noticed over time, and I've talked to Ruth about this, and I don't know if other folks have had this observation, but one big shift I've noticed in the last, like, since I was an advocate to now, I think people tell their stories differently than they used to. So what I hear more nowadays is that victims are better actually at naming the behavior. They're like, oh, this was verbal abuse, right? Like, so they're really good at identifying bad behavior and naming it. And so in a lot of ways, that's great, because I think that what has happened is there's been more mainstreaming of information about abuse, what is abuse. And so victims are very good nowadays at naming that and saying, well, he assaulted me, and then he verbally abused me, and then this and that. What I want you all to help your clients do is to actually pull that back and get them to tell their story using facts. And there's a difference between facts and conclusions of law. So a conclusion of law is I take this series of facts, and if I'm a judge, my job is to determine, did this series of facts meet the definition of battery? The problem with testimony that's a bunch of conclusions of law is it's not helpful to the judge, it's not persuasive to the judge. So if victims come in and they say, he assaulted me, and then he verbally abused me, and also he's a narcissist, none of that is helpful, because it doesn't give the judge what the judge needs in order to make a ruling, and what the judge needs is facts. So if you can help your clients break down what they're saying into, he stepped close to me, he stood over me and backed me into a corner so that I couldn't get around him, and he came within 3 inches of my face and screamed at me. Like, these are facts, they're vivid details. That level of detail is what's necessary to convince a judge that an act of family abuse has occurred. Simply telling the judge an act of family abuse has occurred is not going to persuade the judge. What is persuasive is vivid facts. And I find that clients need quite a bit of help pulling back from conclusions and using and actually phrasing detail by detail what happened. I will tell you that the word rape is a legal term, right? So if a client says he raped me, that's a conclusion of law. What they actually need to do is describe what happened. And that's not easy for survivors to do, obviously, but that is crucial. The most powerful testimony is testimony that is based in facts, not in conclusions. And I think people have a little bit that's like reversed in their mind. I think victims feel that they're more persuasive when they use those words. They are in fact less persuasive, and I think what you'll find is that judges get pretty irritated with that. The other thing is a survivor's fear is important for them to talk about. Fear is not an element of the statute, okay? In very technical terms, I could be, the victim of an act of family abuse, and I might not be afraid, right, of the abuser, but technically speaking, I should still be able to qualify for a protective order. I just think that in real life, what the judge is listening for is this person afraid of their abuser? And so the state of mind, the fear that a victim is experiencing is a fact. It is evidence, it's testimony, right? So I think that fear is important for the victim to talk about. The other thing I would say is that the victim help survivors understand that they should not lead with what relief they're seeking. The relief, things like I need custody of the kids because of this, and I need possession of the home because of this, they can only get relief if they get the protective order. And in order to get the protective order, they must meet a burden to show that an act of family abuse has occurred. So it's important that they actually lead with what happened. And this can be really confusing for victims who feel that at the preliminary protective order stage, they've already told a judge what happened, right? That why do they have to repeat the story? The hearing for the permanent protective order that is where the judge is going to hear both sides of the story. So the victim needs to repeat the story and again, explain what happened before they get to what relief they're seeking. And I think some questions might be coming through. So avoiding, sorry, I'm just kind of reading, catching up. So Sheila is telling me a parent can get a PTO or PO against a minor child, just not an EPO. So I'm wrong about that. I've never heard of that happening, but that is helpful to know. So yeah, it looks like a minor child could be the subject of a PPO or PO, but not an EPO. And then what are some ways we can avoid re-traumatization of victims while still helping them understand what the judge may ask of them during court? I personally think that avoiding surprises is probably one of the best ways to avoid re-traumatizing somebody. So I actually think that telling them very frankly, this is what is going to happen. Even things like this judge is really has a flat affect. It's going to look like he's not listening, or it's going to look like he doesn't care. Be prepared for that, right? You're not disparaging a judge just to say this is what it's like. I think that people have a lot of unconscious expectations about court that they're not necessarily even aware of. But I think that to the extent you can just prepare your client for what's really going to happen, I actually think that is what avoids re-traumatization. Okay, so just moving on to the next hearing really quickly. This varies from jurisdiction to jurisdiction, but the thing that doesn't vary is that petitioners bear the burden of proof by a preponderance of the evidence. So it is important that victims understand they are asking for relief from the court. So therefore, the burden is on them. If they can't persuade the court that an act of family abuse happened, they can't get a protective order. And that feels really unfair, I think, for a lot of survivors. But they do need to understand that, again, the cards from just a procedural standpoint, the cards are a bit stacked against them. And so to the extent they feel like I shouldn't have to repeat the story, I shouldn't have to do this, they just need to understand this is what's going to happen. This might feel obvious, but it is important to tell victims that the respondent will be there. I think that what happens is at the PPO stage, victims get a little bit confused about how the process is going to work, and they don't realize that the respondent, the abuser, is going to be there. They're going to hear everything that they say. And that may seem obvious to you and I, but that's not always obvious to victims. So they need to know the victim will be there. I would prepare the victim for what the physical space is going to look like, what the hallway is going to look like, what the courtroom is going to look like, where are you going to be standing, where is he going to be standing. Really prepare them for physically what's going to happen. The hearing typically lasts about 20 to 30 minutes, and that is generous, and that flies by very, very quickly. So one thing I think that advocates can help victims do is write down their story, and then time them. When they tell their story, time has a way of speeding up a whole lot when we're stressed out, and so that 20 minutes goes by really quickly. There's not always an opportunity for an opening argument. What I recommend when people are representing themselves is they just start by telling the court their name, their address, and how they're related to this person. Because what they really need to establish quickly is that this court has jurisdiction over the matter. And if they forget to say, oh, this is how we are related, right? They don't meet the element of proving that they're family members. It's just really easy to miss that. And so I usually just start by saying, say your name, where you live, what's your relationship with this person, and why are you here today? Why are you seeking? I'm seeking a protective order today because I'm afraid of my husband, because he, and then go into what happened. The petitioner makes their case first, and then the respondent has an opportunity to respond, and petitioners are sometimes given a chance for a rebuttal. And sometimes courts allow for a small closing argument, but it's really important that especially survivors who are going to represent themselves understand you want to get everything out in that first shot, everything. And if you have 10 minutes, like, get it all out, because you don't know, these hearings go quickly, and you don't always know how much time you'll have. If we just go to the next slide, these are just quickly resources for clients. ICANN is the free online program that provides assistance for filing protective orders for survivors, and then the address confidentiality program. So basically that's a mail forwarding service. It's, I think, really great. It provides in the court an address of record that is not the petitioner's actual living address. So if they want to keep their address confidential from their abuser, this is a really great program that survivors can use. And then if we go to the next, just quickly, the affidavit. If you're going to do an affidavit, again, you can attach that separately. I would suggest listing events in reverse chronological order. The reason I say that is if the survivor leads with, this terrible thing happened a year ago, the court is going to be like, well, why are you here now, right? And that's why I would say start with the most present thing and work your way backwards into it. Help the victim identify dates or approximate dates. Sometimes the victim will just say, I don't know when that happened, right? But you can help them narrow down, okay, was it before or after this event? So was it the spring? Was it March, right? You can help clients start to approximate timelines. And again, help them be fact specific and make sure that they are writing in their own words. Really quick, I'm going to go through these last few things really quickly. So Laurel, you advance to, like I said, petitioners can request to extend protective orders. I might submit this. Can you advance one more, Laurel? I think I might submit this to the panel next week. I'm curious, what folks have seen being sufficient events to justify an extension. Basically, what I would suggest is that something usually has to have happened since the final protective order was issued. The original abuse that led to the issuance of the protective order itself is usually not going to be sufficient to justify an extension. So let's say that a protective order was issued 2 years ago, and since that time, he's violated it twice. That is the type of evidence that the court would consider, I think, in extending a protective order. But it's important that victims understand they need to get in before it expires to request that extension. So if we advance one more, modifications. So basically this one, protective orders can be modified, and I'll give you an example. So, and I think we all know this, but the only person who has the authority to change a protective order is a judge. The petitioner themselves doesn't have the authority to say, well, it's okay, I'll make an exception this one time. When we think about modifications, the court is looking at, has something changed since the last order, right? So I didn't just change my mind, right? It's some event has happened that has changed the circumstances that justify a modification. What I really want to be clear about is it's easier to ratchet down than to ratchet up. So this is why sometimes victims are like, well, I don't know if I want the no contact provision. It is easier to ask for it and then get rid of it later than to not have it and then ask for a new restriction later. So if we're asking for the court to be more restrictive rather than less restrictive on the respondent, that's going to be an uphill battle. So modifications, again, the burden is on the person asking for the modification. And then moving forward, these are just the motions to amend. We'll just move through those forms, and then violations. So violations of protective orders are generally criminal, but it depends. So some violations are going to be treated as criminal, and others may be treated as contempt of court. So basically, sometimes people colloquially refer to like civil provisions of protective order and criminal provisions of protective orders. The things that will be treated as things where a respondent should be charged with a crime are violations of no contact orders, violations of stay away orders, those kinds of things. If a respondent basically, let's say, doesn't pay child support as ordered in the protective order, it's unlikely that the police will criminally charge the respondent for that violation. But the victim does have a remedy, which is that they can go to court and issue a show cause motion, basically going to court and saying this person did not comply with the order. But those contact and stay away provisions, like don't come to this address, don't come to her work, don't call her, those things should be reported to the police. And I will say with those civil provisions, I think as quickly as a victim can, they should get into court and file a custody and child support action to replace those provisions, because courts don't usually, in my experience, want to have those ones drag on forever, enforcing or modifying those things. They want that to be taken up in a permanent custody or child support action. And then if we just, Laurel, if you could just advance quickly to, that's it, just questions. And we have our little check-in at the end. Maybe people feel more comfortable, less comfortable, I don't know, but any questions? So some questions around printing the slides, and they will be sent afterwards, after the call. Cool. Well, just as a reminder, please fill out the survey if you have questions. And really, I think that the idea for next week is going to be, we are going to have practitioners who are on the ground, experienced attorneys. They're going to be able to talk about sort of the real world application of protective orders. We're talking about, kind of in theory, how protective orders are supposed to work, and again, what are the available remedies to victims? I think that the benefit of next week is going to be sure, those things are in theory available, but like, how do courts really handle these things, right? And what do judges actually do when a victim does this or a respondent does that? I think it's a really cool opportunity, and I'm really looking forward to that. So I would just really invite you all, if you go back up to the top of the chat, Laurel has posted the Google Doc. I am going to close that link so that Sushila has time to get those questions to her attorneys today. So I'm going to close the business today, close that. So please submit your questions like now, and we'll get those in. But I'm going to submit a couple questions myself, so I'm really looking forward to it, and it's been great working with y'all. And let's do this little smiley face thing again. I hope we're all at green now, but if you can annotate and just show us where you're at. Honestly, just be honest. If you're still exactly where you were before, it's cool too. Maybe next week we'll get us all to the green. Nice. I see more blue and green and less yellow. I love it. Cool. All right, well, thank you guys so much for participating, and thank you to Laurel and Ruth and Sushila for the support. And yes, Sushila is going to, I love just Sushila's comment here, she'll be moderating next week, and we've got legal aid attorneys from Blue Ridge, Eastern Shore, and Nova, which is great because every jurisdiction does things slightly differently. So having that spread will be really great. And like I said, reach out to me if there's anything that, that we at the Action Alliance can do. So to help you or your clients. Anyway, thanks everybody.
Thanks all.